Today we are going to learn the contract in a different way. As you are already aware that Indian Contract Act 1872 plays a very significant role in our syllabus. And this contract is in fact an agreement enforceable by law. So there have been lot of definitions given by different legal thinkers from time to time. We have summed up the definitions and written down 3 important definitions for this class today. What is even more important is that as we enter into contract every day in our day-to-day life, whether it is our personal lives or in our business life, we need to understand the contract properly and ensure its validity. And how a contract, or rather a valid contract, can be made, for this we need to go through certain elements. We can tell them, or we can express them as essential ingredients to make a valid contract. So, for a contract to be made, the primary thing that is needed is an agreement. And there has to be at least 2 parties in entering into the contract. And that must be legally enforceable. That means the contract must be lawful. Now, while studying each of these elements, we come across various legal maxims. Those are generally expressed in Latin terms. And these legal maxims play a significant role in understanding the contract well. Therefore, it is imperative that we understand the legal maxims. Those are generally expressed in Latin terms, and its association with the specific element of the contract which ensures its validity. You will be appearing in different examinations, and you will find that these Latin maxims are coming in your question, in your examinations, as multiple choice questions or sometimes broad questions. But if you are able to understand the Latin maxims correctly, then you will be in a position to make a correct interpretation or the correct explanation of each of these maxims, along with the legal, along with the what is called the element of the contract that is associated with it. So, let's see what a contract is. There have been many definitions provided for contract. Here you can see an agreement creating and defining obligations between the parties. This definition is given by Salmon. Salmon says that it is an agreement. That means in every contract, the agreement precedes the contract, where there will be the rights and obligations between the parties. Each of these parties involved in the contract has to do certain things. So, the very first definition is an agreement creating and defining obligations between the parties. This definition is provided by Salmon. We can see another definition that every agreement and promise enforceable at law is a contract. Every agreement and every promise, right? Contracts are formed in terms of promises made or proposals made. So every such proposals must be lawfully enforceable. the contract which is not lawfully enforceable, which is otherwise contrary to the provisions of any law that are operating in our country, would be rendered void. Therefore, we will have to keep it in mind that every contract has to be lawful in its nature. The third definition is very important here, as because we shall be discussing the contract while being within the ambit of the Indian Contract Act 1872. The corresponding year is also very important. Quite often, it also comes in your examination that choose the corresponding year for the Indian Contract Act, and your answer must be 1872. So, section 2H of Indian Contract Act 1872 says that an agreement enforceable at law is a contract. If you take the crux of the matter, the gist, the essence, then we can pinpoint that there are three things that we get from these definitions. So, there has to be two parties, at least there has to be an agreement, and there has to be legal obligations between the parties involved in the contract. Understood? Now that there are 7 essential elements which I have written down here, these elements ensures the validity of a contract. As we enter into contracts every day, so we must ensure its validity at the same time. How do we ensure the validity of the contract that we make? Each and every contract is an outcome of an agreement. There has to be an offerer and the offeree. There has to be competent parties in the contract. That means the parties entering into the contract must be competent enough to enter into the contract. Right? These parties must be the major. They must have attained at least 18 years of age, and they should be of sound mind and should not be prohibited by any law in our country to enter into a contract. And when we talk in terms of the soundness of mind, the person must not be an idiot, a lunatic, or a drunkard. Right? So, then there is the third element here. We can see that it is about free consent. Every contract entered into must be with the free consent of the parties. That means that the parties involved in the contract should not exercise coercion, fraud, undue influence, misrepresentation, and mistake. If the parties, one of the parties rather, exercise any of these elements, then the contract can be rendered into a void contract or voidable contract. Right? And then there has to be consideration. Each and every contract must be having consideration. In the language of law, the meaning of consideration is something given in return. That means each party has to do something for the other party. So consideration is one of the important elements of a valid contract, and this consideration has also to be always legal. Okay, rather lawful. Well, the next element here is not expressly declared void. That means we should not enter into a contract which is not declared void by its very nature. For example, if you enter into a contract with a minor, then that becomes void. So, we'll have to take into consideration all those aspects which should not render the contract void. For example, another example can be given that you are not supposed to enter into a contract with a convict, a person undergoing imprisonment, or a foreign diplomat, or with the national of a country with which India is at war. So you will have to keep it in mind while entering into the contract. And then the last one is the compliance with legal formalities. Wherever legal formalities of distinct nature is required, you will have to comply that. For example, if you have to buy a house, you will have to invariably go for the registration. You just cannot simply write down on a piece of paper and then execute the contract that way by the buyer and the seller. So that is not valid. So wherever the legal formality is to be duly complied with, we will have to stick to these formalities, and only then the contract will be executed legally. Now that linking these elements with the legal maxims or Latin words, the importance of legal maxims, which are generally expressed in Latin terms, have been very significant in law. Since a long time ago in the Europe, the Latin language used to be prevalent and extensively used in law. So those Latin, words have eventually crept into all spheres of legal aspects. Now we find that what are all these legal maxims? That we must know that first. So a legal maxim is a well-established legal idea, a proposal, a doctrine generally expressed in Latin. Right? So legal maxim is a well-established legal idea, proposal, doctrine generally expressed in Latin. And we quite often come across these Latin terms in the contract. Now I am going to show you the popular Latin terms or the legal maxims that are used in describing the elements of a valid contract. Right? So let us take the very first one as agreement. Here the Latin term used is, or the maxim used is, pacta sunt servanda. That means the agreement must be kept. That is a very, very important Latin maxim, that every promises must be kept. And it forms the basis of the civil law as well as the international law. The next one is the competent parties. In order to ensure the parties are competent, we have already discussed that the parties has to be mature, that means must have attained the age of majority, that is 18 years of age. Right? But so if you are entering into a contract with a minor, then the contract becomes void ab initio. That means void from the beginning. Void from the inception stage itself, the contract becomes void. From the inception stage itself, the contract becomes void. It cannot be subsequently ratified by the minor on attaining majority. So that is what is called competent parties. The next in the order is the free consent. The parties involved in the contract must give their consent freely. So a consent is said to be free when few things are absent. That means there is no coercion, there is no fraud, there is no undue influence, there is no misrepresentation, there is no mistake. In presence of all these elements, the contract will be either voidable, or in the case of mistake itself, it becomes void. That means, if the contract is done by means of coercion, by means of undue influence, by means of misrepresentation, then the contract is voidable, and if it is done by mistake, then contract can be void. Therefore, the contract will not be a valid one. You have to understand that. So, this is expressed in Latin as consensus ad idem. That means there has to be perfect identity of mind. Understanding the same thing in the same sense is of paramount importance in explaining the free consent here. Otherwise, whenever we are indulged or involved into a contract with those elements as has been cited just a little while ago, specified a little while ago, we might cause or we will cause error in causal, mistakes in making a contract. Then there is the consideration. I said that in each and every contract there has to be a consideration. It is also said that no consideration, no contract. No consideration, no contract. Or you can say that ex nihilo pacto non oritur actio. Without consideration, a promise is a bare promise and there is no legal standing. So consideration is best expressed in Latin as quid pro quo. That means something for something or something given in return. Then the next in the order is not expressly declared void. In Latin it can be said as non expresse declaravit inanimus. So we are entering into a contract which has been expressly declared as void. By any law in our country, we cannot enter into a contract. For example, you cannot make a contract wherein your object is not lawful. You cannot do a business with atomic energy substances. It is strictly prohibited by law in our country. So we'll have to ensure that. And the last one is compliance with legal formalities. Here the Latin is obsequio iure solemnia. That means every contract, in order to ensure its validity, we must comply with the legal formalities. The formalities involved in making a contract must be duly complied with. I hope that you have been able to understand the legal maxims or the Latin terms associated with each of these elements in today's class. And therefore, to conclude, let's go back to the 23rd century BC, wherein the Greek writer Horace stated that carpe diem. Okay, so let's take the spirit of the day. Thank you very much.